If you run a law firm, you already know every missed call could be a missed case. But when you're in court with a client or buried in paperwork, picking up the phone just isn't always possible. That's where Posh comes in. With Posh, every call is answered like it's your most important one. New leads are captured and scheduled so your pipeline keeps moving without interrupting your day. Don't lose another case. Start your 7-day free trial at posh.com or call 833-GET-POSH.
Welcome to Brief Encounters and to the June episode of the Securities Regulation and Enforcement series. I'm Valerie Mirko. I'm a partner at Armstrong Teasdale as well as chair of the firm's Securities Regulation and Litigation practice. And with me is my co-host, William Nelson, who will go ahead and introduce himself.
Yeah, thanks, Valerie. William Nelson. I'm the Director of Public Policy and Associate General Counsel at the Investment Advisors Association. And today, Valerie, we actually have a lot to talk about. So I'm really excited for this episode because I think it's a lot of meaty issues to dig into.
Absolutely. And, we're about 13 months into Chair Atkins' tenure, about 18 months since Chair Gensler departed, or just a little under. And it's really fascinating to think how much has happened. About this time last year, there were definitely whispers of, are things going to be quieter at the SEC? And in my experience, they have not been, nor have they been in yours, William.
Yeah, no, Valerie, you're absolutely right. Thinking back, there was a thought that, with the really rapid pace of Chair Gensler coming out, a lot of rulemakings, a lot of changes being made, I think there was a thought that going back, back to the basics, we've heard Chair Atkins talk about this before, but it really has been pretty, fast and furious, both, in the guidance area, but also more importantly in the rulemaking space as well.
No, absolutely. And there has been a bit of a slowdown in enforcement, but it has certainly not come to the standstill that I think some stakeholders were expecting. I think priorities are getting a little bit redistributed, and we can talk about that more. But this whole idea of, we were calling it back to basics last year, but it's really at this point core issues or heartland issues. That's the common point between enforcement exams and rulemaking. There's a real look at the core mission of the SEC and at the basics of disclosure and regulation. So we have an ambitious list of items to touch on today. I'm kicking it off with a couple enforcement-related updates. So first and foremost, there is the rescission of the no admit, no deny policy, which was a longstanding policy that the SEC rescinded in May, so just about a month ago. And this policy had historically been used since 1972 when respondents were negotiating settlements with the Division of Enforcement. And the longstanding rule permitted respondents to settle enforcement actions without admitting wrongdoing, so long as they refrained from publicly denying the SEC's allegations. And that longstanding rule and policy has been rescinded. To make this change, the SEC formally rescinded Rule 202.5E of the agency's rules of procedures effective back in May. So now, going forward, what does this mean? Respondents will be permitted to issue a public denial of the SEC's enforcement charges after entering into a settlement agreement. In practice, however, I think respondents, as well as their counsel, will need to continue to weigh the facts of a matter and the regulatory and industry context of the particular matter. So, in an interesting way, with this policy being rescinded, the admission of wrongdoing, paradoxically, is now going to take heightened importance, because there's, at least in my estimation, but if you read across thought leadership from other defense counsels, There's a strong possibility that the SEC will seek more specific admissions to anchor factual findings, and then respondents will in turn be concerned that these findings could trigger additional collateral regulatory, litigation, or reputational consequences. So actually, when we were preparing to record today's episode, we were talking about, is there anyone we could talk to who negotiated settlements before the policy, so before 1972, which, as people can imagine, that will take some doing to find someone who we can have that conversation with. But it's a big change, and it's not a change we're going to see the results of quickly. There will be a phase where the orders will not look quite so different. And then in the next few weeks or months, we're going to start to see some changes. But something important to remember, though, is there will be no enforcement of these no-deny provisions for previous settlements. So I think change has begun, but will move slowly. And then there's also the fact that future enforcement matters could also be settled without admitting to facts or liabilities. So there's still discretion retained by enforcement staff in how they negotiate these settlements. And like I said, I think it's going to take a little bit of time before we really see the impact and how it plays out. Now, as everyone who listens to this podcast knows, there is a new enforcement director, David Woodcock, at the helm of this. His role as enforcement director essentially makes him the shepherd of implementing this rescission of no admit, no denies. So I think it's to be continued. Enforcement Director Woodcock was in senior leadership at the SEC in the past, in the Fort Worth regional office. He's a very accomplished lawyer. He's been in-house at a public company. He's also been at a couple of law firms. He's been on the staff before. So I think based on his experience, he understands the sort of delicacy of how to implement this new paradigm. And I look forward to seeing how that plays out. So that to me is the biggest news on the enforcement level. There is, of course, we do have to talk about this because it is a Supreme Court decision in Sripech v. SEC 9-0. The decision reaffirmed the SEC's power to pursue victimless disgorgement in future enforcement actions. Important because it is a Supreme Court decision, not a surprising outcome for any of us in the defense bar. And I think it just reaffirms the fact that the SEC will continue to use disgorgement as one of its many, many tools. So, William, what should we cover next?
Yeah, absolutely, Valerie. And just going back to your point, it's great to hear kind of the practical view because, a lot of what you see in the press when it comes to this, what they call the gag rule was that companies and firms are, free now to basically say whatever they want. There's a lot of shouting about the First Amendment, but it is really interesting to hear kind of more the practical perspective that we may see a lot of change, we may not, but it's definitely going to take some time. Since we are on the topic of enforcement, easy switch over to exams. And we just did have a little bit surprising to us, some of us in the industry, that, some of the issues that just came out in an exam risk alert from the Division of Exams. So I know, Valerie, you were going to chat a little bit about that.
Absolutely. And for our listeners, this is the Division of Examinations risk alert of June 9th. So just a couple days ago. And it focuses on investment advisor obligations related to economic conflicts of interest. And it's a series of exam findings. None of them surprised me for two reasons. Some of these exam findings mirror conduct that we've seen in recent enforcement settlements. And some of these exam findings also mirror some of the issues that I'm seeing in the examinations that I'm defending at the exam level. So there's certainly a lot of issues here that I'm very familiar with and that many defense counsel are very familiar with. But I think it's important to run through them. And something that I'm going to put out there as somebody who spends an inordinate amount of time thinking about these issues is, yes, they are economic conflicts of interest, but they may be showing up in an exam setting under a duty of care discussion with the staff, as opposed to purely a conflicts discussion. And the reason I bring this up is there's a range of issues ranging from advisors' cash management recommendations, which at times is a conflicts issue, but at times is a duty of care issue. And for broker dealers, cash management recommendations has also come up as a care obligation issue in Reg BI exams. But moving on, the risk alert, back to just Advisors Act issues only, speaks to what they call other revenue opportunities. A lot of us call that rev share and mutual fund share class selection issues. That's in the risk alert. And I think that's very helpful because we certainly, those of us who do this a lot know that mutual fund share class is very much an issue that the staff is interested in, but it is helpful to have a very fresh or recent marker from the staff with this risk alert regarding mutual fund share class selection. And then we get into the disclosure of fees, economic conflicts. And then even though the risk alert is titled economic conflicts of interest, then we really get into what to me are just care issues, fees deviating from advisory agreements and fee-related disclosures, compliance programs identifying and addressing fee-related disclosures, the calculation of fees, having fees that are consistent with services that are actually provided. Like, these are not solely conflicts issues. They're also care issues. And they very well may come up, depending on the exam team, under a duty of care violation as much as under a duty of loyalty violation. And I realize I'm going deep into the weeds in this, but this is as somebody who has spent many, many, many years thinking about investment advisors' fiduciary duty and practicing in this space. There are certainly nuances as to when is it more of a conflicts issue, when is it more of a care issue that I really wanted to crystallize. But this risk alert is very helpful to those of us in the defense bar because it tells us what is top of mind for the staff. Nothing in it is surprising me, but I always really appreciate when the staff puts out risk alerts because we can also point to them when working with our clients. And I know that in-house counsel really appreciates risk alerts because it is something, again, which is very timely that they can work through with their business. So to me, that's a very positive thing. But, we also know, and this has been said publicly, that these exam risk alerts are also reviewed to some extent by enforcement leadership. So these are not just exam risk alerts. These are also telling us what's on the mind of senior enforcement staff. And that needs to be remembered. They are part of the stakeholders who review these risk alerts. That has come up in a public setting many times in my career. And also, I'm unsurprised because many of the observations in this risk alert align with recent settlements.
Yeah, and that definitely all makes sense. I think it's a great point to make. I know for our members, they really like these risk alerts because, again, they can use it to go back to their policies and procedures, their controls, ensuring that, yes, we are billing our fees correctly. We are ensuring that any kind of conflicts, third-party payments, revenue sharing is being disclosed appropriately. So, I think anytime the SEC is willing to put these out, I think it's so helpful for our members, but I know for the industry as a whole.
That's exactly right. To me, these risk alerts are really a net positive because there is often the issue of, well, are they more granular? Are they prescriptive? And I don't take them that way. To me, it is exactly what I just said before, which is it is what is top of mind for the exam division and also to some extent enforcement leadership. And that to me is what is helpful about the risk alerts. I may quibble with, is it conflicts? Is it care? But at the end of the day, what matters is these are observations that matter to the exam division and to enforcement staff. And therefore, it should matter to us as defense counsel, to you, William, at a trade association for investment advisors, and of course, to all investment advisors and their in-house counsel and compliance folks. So moving on, though, we've talked about enforcement and exams. But there's a lot going on also in terms of capital formation. And William, I was hoping you could fill us in on that.
Yeah, absolutely. And I think this goes back. I know this is something we've discussed in previous episodes. Chairman Atkins kind of mantra, make public markets great again, doesn't, fit as well in a hat, but I know it's definitely one of his, the main focus of the SEC. So they have put out a few different proposals. One was kind of a more simple high level proposal. So currently, public companies have to report certain financial and non-financial information on a quarterly basis. This proposal would give them the option. It would not be a requirement, but it would give public companies the option to report semi-annually instead of quarterly. There are arguments on both sides to this. Obviously, some companies may think, hey, quarterly reporting leads to short-termism. We'd really like to have a longer cadence. Semi-annual would be, a good fit. You also have others, even potentially more on the asset management side, the buy side, really looking and saying, hey, we do like getting this information quarterly. That's helpful for us to have a good view into the business. Definitely helpful when we tell our clients, when we talk about their investments. So that was the first proposal, but there's also a much more expansive proposal that really focuses on streamlining forms, streamlining disclosures, reducing burdens on being a public company. And some of the key takeaways from that proposal, right now, there's what's called well-known seasoned issuers. These are, what they're called WIXIs, very large companies that do have access to streamlined forms, don't have to do a lot of what goes into, these initial public offerings. So basically what this proposal would do it would really replace that framework, the WIXI framework, with two new categories: eligible listed issuers and then also seasoned eligible listed issuers. So again, these categories would have lower qualification thresholds than the current WIXI standard, which again is what you'd think about as, your Apples, your Microsofts, very large companies, very large public floats. And as a result, we see a lot more public companies now could access benefits such as pay-as-you-go filing fees, give them more flexibility to communicate with investors before and after filing the registration statement, ability to add securities or issuers after the registration statement becomes effective, broader rights to omit information from a prospectus. So again, that's a big deal. Also, it would allow them to basically make that short form available to more companies so they could do what's called a shelf offering. So again, anytime they want to come out with new securities, take it off the shelf. It would also eliminate the current 1-year exchange reporting history requirement. So again, generally right now, you'd have to have 1 year of Exchange Act reporting. This would eliminate it. So a company that's current, that's timely in their SEC filings, could generally use that short form as soon as it becomes a reporting company, subject to certain exceptions. It would also modernize Form S1, which is the form that's used by most companies going through their initial public offering. Generally, there's a big focus on what's called incorporation by reference. So again, they would be able to incorporate information from other documents into that registration statement. So again, future Exchange Act filings could automatically update the registration statement. I know there's also conforming changes to business development companies, BDCs, and also registered closed-end funds. So again, I think the goal here is really creating more parity with operating companies. So again, they would be able to use the short form registration statements as well. Another big part of this, which again, I know impacts a lot of our members that are in the private fund and private equity space, is that it would broaden federal preemption of state securities registration and qualification requirements. Right now, the preemption generally applies to only registered offerings of securities listed or approved for listing on a national security exchange. And what this change would do, it would basically broaden that preemption to cover all registered offerings, including offerings of unlisted securities. So again, that could be a huge deal when it comes to the private equity world. So, this does do a lot, as you can see. I think, again, it's really focused on, streamlining forms, making it easier for companies to go public. There has been this thought over the last 5 to 10 years. We have seen a material decrease in the amount of companies going public. I think from, definitely our perspective, we want a very robust, a very healthy public market. So again, we'll kind of see this is just a proposal. So they're going to go through the rulemaking process. So it'll be interesting to see kind of what comments they get from both sides, potentially from consumer groups, industry groups. So it'll be really interesting to see. But I do think that, if this is ultimately adopted, it could really expand capital raising flexibility for those kind of smaller and newly public companies. And again, extend those similar benefits to the business development companies and also the closed-end funds. So this could be a really, really substantial change in the public offering market. So again, it's just a proposal. I'm sure on a future podcast, once we get the final rule, we'll refer back to this and talk about it. Since we are on the rulemaking path, Valerie, I know you were going to talk about some of the upcoming rulemakings that we're seeing from the SEC.
No, that's exactly right, William. And, I had to grin a little bit when you said it's just a proposal, because I do think we are at the beginning of the Atkins Avalanche, by which I mean Atkins rulemaking avalanche. And it's a little bit paradoxical, right? We're still waiting on a Reg Flex agenda. It hasn't been updated since spring of 2025. So the current Reg Flex agenda we can look at, which is from spring of 25, does not reflect Chair Atkins's current priorities. But we've also heard anecdotally, whether it's at conferences or just generally in conversations, that the SEC is expecting to release up to 30 rule proposals this year and perhaps again next year, which is a very ambitious agenda. So I find all of that really fascinating, especially because these are the rules that, once adopted, are going to be top of mind for the enforcement program. So that, I care about them for multiple reasons, but that is the main reason I do care about seeing what happens in rulemaking. Like, what does that mean? How will this shape industry conduct and so forth? So there's a lot that's about to happen. It is starting to happen. We're recording this on June 10th, and there is an open meeting tomorrow, which is the first open meeting that the commission has had since September 17th. And that's an awful long time to not have an open meeting. I like open meetings. I think they're helpful for debate. They're helpful for transparency. So I'm really glad there is an open meeting. I think rulemakings should come with an open meeting, both at the proposal level and the adoption level. But that's just my point of view. That said, it is important for transparency. So is the Reg Flex agenda, some would argue. There is transparency in that rules have had to be submitted to OMB for White House approval since, the last few months. But I very much land on it's helpful to have open meetings for proposals and adoptions. It's helpful to have an updated Reg Flex agenda. I'm less wedded to that than perhaps some of my regulatory colleagues are. But I do think we're about to see many rule proposals.
Yeah, Valerie, and that's a great point. And it's interesting on the regulatory agenda because even though they haven't taken any action on that, they did recently, and this is on their website, put out their strategic plan for the next 5 years. And, I won't go into depth on this podcast, but, a few of the goals are really interesting. The first, not surprisingly, renew the policy to focus on supporting innovation, supporting capital formation, shifting their regulatory practices to increase stakeholder engagement. And that one's really interesting. And it goes back to your point, Valerie, about not having an open meeting since last September. And now you have the strategic plan that really is focused on increasing stakeholder engagement, facilitating the compliance efforts of market participants. And again, that's something we definitely welcome, but it is interesting just juxtaposed with that lack of open meetings, but also the other goal to optimize their operational efficiency. And again, you could imagine what this means, and it really is focused on the use of artificial intelligence, whether that's in the exam program, the rulemaking program, the enforcement program. We could definitely see much more use of that technology going forward over the next few years. And also, not surprisingly, under that regulatory policy focused on innovation, the number one listed issue is digital assets and crypto. basically providing that firm regulatory foundation. We're still waiting on market structure. The Clarity Act did pass the Senate Banking Committee, but again, it still needs to pass the Senate and go back to the House. The SEC did propose on the rulemaking front what they called their innovation exemption, basically, almost a sandbox environment for certain digital assets and crypto assets. It's still, as far as we know, at OMB, the Office of Management and Budget in the White House. So we still haven't seen, the final rule for that or what that's going to mean. But it is interesting, though, the strategic plan does kind of give you an idea, even though we don't have the regulatory agenda, kind of the issues that the SEC is focused on. But again, I know you can't be on a podcast today or go to a conference without talking about artificial intelligence. And I do really think that internally, we have heard that the SEC is really trying to utilize it to optimize their efficiency. So I thought that was a really interesting note.
I think efficiency is something across all sectors is top of mind, whether it's the public sector, the private sector, the financial services industry, outside of the financial services industry. There's a lot of debates about AI, and we're coming to the end of our podcast. So obviously, I can't address all of them, nor could I without at least a couple of days worth of time. But I think what we do need to remember is where AI can be a very positive addition, it's increasing efficiencies, as long as it's used deliberately and wisely and with human intervention. And I do think that's where we're seeing a lot of optimization happen, both for regulators as well as for industry stakeholders.
Yeah, and all great points, Valerie. And I think we are going to see kind of that transition. But it will be interesting to see, like you said, in all sectors, but especially at the SEC, how that factors into, exam prep, into enforcement. But as you said, we are running out of time. So many different issues to talk about. That's what I love about this industry. It just seems like there's always new issues, emerging issues, even the risk alert that just came out. It's issues that we've seen before that still pop up. So it never lets us stay bored for long.
I think that's exactly right. So we've wrapped up our June episode. We will be back in July with updates on some of these issues and perhaps even a guest speaker. So I very much look forward to our next episode. William, thank you again for taking the time to discuss all these timely issues. And until next time.
Of course. Thank you, Valerie. And again, another great episode. And hopefully all our listeners appreciate it. And we'll see you next time.
This episode of Brief Encounters was brought to you in part by our sponsor, Posh. Start your 7-day free trial at posh.com or call 833-GET-POSH.